Hordes of looters are ransacking homes in the fire-ruined areas of Los Angeles, and homeowners are now forced to consider how to best defend their homes and property from these opportunistic, thieving scavengers. I'm seeing people suggest, you loot, we shoot. But is it lawful to use a gun against looting, or do you put yourself at risk of a murder conviction? The answer might surprise you. I am, of course, attorney Andrew Branca for Law of Self-Defense, and for those of you who stay to the end, I'll share with you how you can get a free copy of our best-selling book, The Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. Even as the utterly predictable wildfires made possible only by government ineptitude continue to ravage communities around Los Angeles, local residents are being compelled to face yet another calamity. Hordes of ravaging looters swarming over their homes, burned in fires or momentarily abandoned out of necessary safety. And as always happens with looting in the aftermath of a disaster, there are simply inadequate law enforcement resources to do much to stop it. Here's a news report of a community resident out of Los Angeles.
As I was getting my whole family out, all you have in your mind is just you're in survival mode at that point. I saw men coming into our neighborhoods. Police confirmed it. She had this to say. Take a listen.
It was wild. We just started seeing all these cars pull up, doors open, and groups of men running up our street, going up to the doors of these houses. And we weren't sure what was going on. I'm thinking, are these people here to help my neighbors? I hope so. And I left, and then my husband talked to the police and said, what are those guys doing? These guys don't live here. Get them out. My next door neighbor said, his quote, there were like 100 people that came up on scooters and were trying to get into any and all houses on the street.
And did you physically see police officers stopping them?
I didn't.
And here's a post from X and some images making further note of the widespread looting taking place. It reads, it really is remarkable how quickly the illusions of modern liberalism evaporate once the social order collapses. The California fire started on Tuesday. Within literal hours, the looting began. Groups of men were pulling up to homes en masse, by the hundreds, according to some eyewitnesses, in cars and scooters across Los Angeles. Wherever the fires burned, the looters appeared. And here's a news report image noting the looting. And here's a headline from just yesterday referring to the looting environment as the Wild West. Now, California, like every state, has laws that allow for the use of deadly defensive force under particular circumstances. But does California allow for the use of deadly force to stop looting? Is you loot, we shoot valid California law, or is shooting a looter simply murder? Now, looting is a pretty serious crime under California law. Essentially, the crime occurs when somebody commits a burglary, that is, unlawfully enters a home for the purpose of committing a crime, during a state of emergency. A first offense is good for 3 years in prison and a $10,000 fine, and it counts towards California's 3 strikes sentencing scheme, in which a third felony strike is good for a minimum of 25 years in prison. But all of that only tells us what the government might do to a looter once convicted. What can you lawfully do to a looter to prevent or stop the looting in the first place? And the answer under California law is not much. You can, of course, use force to protect the property in your home from being stolen, just as you can protect any of your personal property from being stolen. But unless there is a forcible felony that threatens human life also taking place, you are limited to using only non-deadly force. And even then, you may use only just non-deadly force only to protect property in possession of yourself, your family, or your household. If you see your neighbor's home being looted, you have zero legal privilege to use any force whatever to protect your neighbor's property. Meaning that if you do it anyway, you're committing a crime against that looter for which you could be prosecuted. Unimaginable? Are you sure? Remember George Zimmerman being prosecuted for defending his life against an apparent burglar? Remember Kyle Rittenhouse being prosecuted for defending his life against violent rioters? Remember Daniel Penny being prosecuted for defending his life and the lives of others on the subway car from a violent lunatic? Now, of course, if the looter in question isn't merely a threat to property, but is also a deadly force threat to persons, well, then we're dealing with a self-defense or a defense of others scenario, not merely a looting scenario. And even California law has much broader permissions for the use of deadly force in defense of life than in defense of mere property. But here I'm speaking just to the pure looting scenario, without a threat to persons. What about the fact that the property theft taking place is happening in the context of a burglary of a home, your very castle? Doesn't that give you broader permission to use deadly defensive force? The answer in California, sadly, is not really. California does allow you to use deadly defensive force against someone attempting to unlawfully enter your home in a violent, riotous, and tumultuous manner. So if the looter's kicking down your door to get in, that might give you all you need to use deadly defensive force. But what if the looter simply walks through the front door that you left open while talking to your neighbor out on the lawn, or walks in through your temporarily open garage door while you were loading your car to evacuate? Or a later looter casually steps through a door that was smashed open, not by themselves, but by a prior intruder. They're not entering in a violent, riotous, or tumultuous manner, and so would not trigger this particular privilege for the use of deadly defensive force. And that's true even if it's a dozen or 24 people casually walking into your home to ransack it. California also allows for the use of deadly defensive force against someone unlawfully entering your home to commit a forcible and atrocious crime. And in most states, the mere act of burglary in a dwelling would be sufficient to trigger this privilege to use deadly defensive force. Even fellow liberal state New York allows for the use of deadly defensive force to prevent a burglary of a dwelling. The California appellate courts, however, have interpreted the California version of the law to require that the forcible or atrocious crime being stopped be a crime whose character and manner reasonably creates a fear of death or serious bodily injury to a person. So the mere burglary is not enough, and the threat of death or serious bodily harm to persons is basically the same as what's required for straightforward deadly force self-defense. So this really provides no additional privilege for the use of deadly force in defense of property, even your castle. I should also mention that California does provide, in the case of an unlawful and forcible entry into your home, a legal presumption that you had a reasonable fear of imminent death or great bodily injury at the hands of that unlawful and forcible intruder. And that's great. But again, what if the looter in question is simply stepping through a doorway that was smashed by a previous looter? That second looter is entering unlawfully, but not forcibly, and so the legal presumption of reasonable fear would not be triggered. Now, that's all the black letter law, and it's fairly similar to black letter law in most other states. But there's the black letter law, and then there's how the authorities might apply that law, especially to a homeowner defending his castle from looters in the aftermath of a natural disaster. I mentioned the egregious persecutions of Daniel Penny, Kyle Rittenhouse, and George Zimmerman. Each of those were choices that were made by prosecutors to bring those cases to trial. The prosecutors could just as easily have used their discretion to not try those cases, and typically would have done so on those facts, which is what makes those cases appear as persecutions rather than prosecutions. In the state of Florida, government officials have in fact gone a long way to suggest that they would turn a blind eye to the use of deadly force to prevent looters. In fact, Governor DeSantis even used the phrase, "You loot, we shoot," in a press statement following a recent hurricane in the Sunshine State.
Told all of our personnel at the state level, you protect people's property, and we are not going to tolerate any looting in the aftermath of a natural disaster. I mean, it's just ridiculous that you would try to do something like that on the heels of an almost Category 4 hurricane hitting this community. I'd also just remind potential looters that you never know what you're walking into. People have a right to defend their property. This part of Florida, you got a lot of advocates and some proponents of the Second Amendment. And I've seen signs in different people's yards in the past after these disasters. And I would say it's probably here You loot, we shoot. You never know what's behind that door. If you go break into somebody's house and you're trying to loot, these are people that are going to be able to defend themselves and their families. So I would not do it. We are going to hold you accountable from a law enforcement perspective at a minimum, and it could even be worse than that, depending on what's behind that door. So let's all band together and lift people up and not try to take advantage of a difficult situation.
And the always entertaining Sheriff Grady Judd of Polk County, Florida, echoed similar sentiments following that same hurricane.
People have a right to be safe in their homes. They have a right for their property to be safe, even when part of their home may be torn away. And these looters, that's unacceptable, absolutely unacceptable. I would highly suggest that if a looter breaks into your home, comes into your home while you're there to steal stuff, that you take your gun and you shoot him. You shoot him so that he looks like grated cheese. Because you know what? That's one looter that won't break into anyone else's home and take advantage of them when they're the most vulnerable and the most weak.
Now, I don't have videos of actual Florida prosecutors expressing similar sentiments publicly, but there is an important difference in the black letter law of Florida compared to California on this looting issue. Florida does allow the use of deadly defensive force to prevent the felony of burglary. Indeed, burglary is specifically enumerated in Florida law as a felony against which deadly defensive force is permissible. Now, perhaps after things settle down in California, the voters of that state will encourage its legislature to pass similar black letter law, though given the progressive supermajority in the legislature, I'd have to say good luck with that. So the bottom line in California is that you loot, we shoot is not actually a legally permissible use of deadly defensive force. Now, I don't tell people what to do. I only try to help people make informed decisions. If you decide in that circumstance to go ahead and shoot a looter in the absence of a deadly force threat to persons, well, that's a physical option available to you, I suppose, at least if you were thoughtful enough to have acquired a gun at least 10 days prior in order to accommodate California's 10-day waiting period. Just keep in mind that if the matter comes to the attention of the California authorities, you're escaping criminal liability only if they decide to exercise their discretion to not prosecute and convict and sentence you under circumstances in which they have complete legal authority to do so. And again, good luck with that. And that's about all I have to say about that for the moment. Folks, before I wrap up, I do want to share with you how you can get your free copy of our best-selling book, The Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. We translate all the legalese into plain English so you can make better informed, more confident, more legally sound, and more decisive decisions in defense of what you value most. And perhaps best of all, most people tell us they can read the entire book in less than an afternoon. Check out the book on Amazon where it's 5-star rated, but don't buy it there. They'll charge you $25 for the book, plus shipping and handling. Order the book from us, and we only ask that you cover the cost of shipping the book to you. The book itself is free. Grab your free copy of The Law of Self-Defense Principles right now at lawofselfdefense.com/free book. I'll close up by reminding all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca at lawofselfdefense.com. Stay safe.